Joint hearing of the Committee on Cannabis Policy to order. Perfect timing. Literally gavelled like 2 seconds ago. But today we're holding our second informational hearing to continue our review of the Cannabis Control Commission's enabling legislation. Today, in our search for opportunities to improve cannabis regulation in the Commonwealth, we'll be engaging with perspectives from the fields of cannabis policy, administrative law, and public health. We will hear presentations from experts in those subjects, followed by questions from committee members. Written testimony will also be accepted and can be submitted using the instructions on the hearing webpage. Just take a minute to introduce my co-chair, Senator Adam Gomez. You want to say any words or introduce the senators?
Hey, thank you, Mr. Chairman. Happy to be here again for a fruitful discussion. I am joined by my partner here in the Senate, Senator Pavel Payano. Happy that you are here present. And also just looking forward to today's testimonies.
Excellent. Thank you. I'll just take a moment to introduce members of the House that are with us. We have Representative Vanna Howard of Lowell, Representative Aaron Saunders of Belchertown, Representative Donnie Berthium of Spencer. Correct.
Mr. Chair.
Yes, and Representative Sauter of Bellingham. I apologize to the two members for getting their. I got your districts correct. I just got your towns wrong. And joining us virtually, we have Senator Robin Kennedy of Worcester and Representative Sousa of Framingham, who are joining us virtually as well. Just before we start with the testimony, I just want to say thank you to all the public who has joined us today. Just a reminder that when the legislature created the CCC in 2017, it was truly charting unknown territory. And today, we have many guideposts available to us as we revisit the original enabling legislation, including the experience of stakeholders in the now established industry. Committee members heard about the day-to-day experiences of these stakeholders at our October meeting. At this hearing, we will build on that testimony with the aim of exploring reforms that will allow the CCC to fulfill its mission with minimum continued legislative oversight or intervention. The committee is grateful to the testifiers who are here today to help us as we navigate a nuanced and sometimes thorny policy area. We are particularly interested and excited to hear your testimony and hope that you will bring a more global perspective to the issues we are dealing with here in the Commonwealth. We are here to support a thriving and successful cannabis industry in Massachusetts. The legislature's goal is looking to support its continued growth and evolution, as well as support the Commonwealth's consumers and patients. And just a couple quick notes. We don't have any panels today, but we have individual testifiers. So we'll let them bring their testimony forward, and then I can facilitate questions from all the committee members. So with that, I think we'll turn to our first testifier, who is virtual, and that's Professor Renee Landers. So Professor Landers, are you with us? And just as she's getting on, just a reminder to the testifiers as well as when we call on you, if you just introduce yourself, provide any background information that might be interesting to the committee, and then you can provide your testimony.
Eric's already on here, so if we need to switch to Eric while she's getting this, we could bounce to Eric if we need to.
Yeah. Just gonna give her 30 seconds to make sure she can log on, and then we'll go.
Yeah, we could bounce back to her.
All right, we'll come back to Professor Landers. So we'll go to the next testifier, Eric Gunderson. Eric, are you online?
Should be. Can you guys hear me?
We can, yes. Thank you so much. Thank you for bearing with us through technology.
Yeah, no problem. Good on the fly here, so. All right, so good morning, Chairman Donahue, Chairman Gomez, and members of the Joint Committee on Cannabis Policy. My name is Eric Gunderson. I'm the founder and principal of ERG Strategies, a consultancy dedicated to guiding states and tribal governments through the complex landscape of cannabis policy and regulation. Before founding ERG Strategies, I served as the executive director of Maine's Office of Cannabis Policy, where I led the implementation of Maine's adult use cannabis program. My responsibilities included drafting and securing passages of the initial regulations, design and execution of application and licensing processes, launching Maine's adult use cannabis program in 2020, engaging with stakeholders, and most relevant to today's discussion, establishing and scaling Maine's cannabis office, at the time the newest agency in state government. By the end of my tenure, OCP had grown to over 40 dedicated staff members with efficient workflows, systems, and most importantly, a strong culture grounded in well-defined mission, vision, and guiding principles. Prior to my role at OCP, I worked with the Maine legislature as a senior policy advisor to two Maine speakers. Starting in 2017, I served as the policy liaison and support for the Joint Select Committee on Marijuana Legalization and Implementation, the committee established to redesign Maine's Legalization Act, approved by Maine voters in 2016. This experience equipped me with a deep understanding of the unique challenges involved in crafting, implementing, and administering well-informed cannabis policies. Now, after 4 years of OCP's executive director, I founded ERG Strategies to support and empower state and tribal governments as they navigate the complexities of cannabis legalization. Together with Cannabis Public Policy Consulting, ERG Strategies has partnered with 15 state and tribal entities to share best practices, provide strategic guidance, and promote regulatory frameworks that incorporate the insights and lessons learned from my career. So why I'm here today. As the committee considers the best cannabis regulatory governance structure for Massachusetts, it's essential to recognize there's no single right answer. Instead, the committee should thoughtfully prioritize its objectives for the Cannabis Control Commission, allowing for an ideal governance structure to emerge naturally. In my testimony, I'll provide my perspective shaped by my experience as a state cannabis agency executive director and a consultant to several state cannabis agencies. I'll do my best to address the executive director model, or you could call it the chief administrator model, versus the commission or board model, and examine the pros and cons of each. Key elements that contribute to a successful government agency, the role of agency culture and how governance structures can shape it, centralized versus decentralized agency models, and how to ensure success after a governance decision is made, because that's truly when the hard work will begin. But before I dive into these topics, I feel compelled to share that in my experience with both the state of Maine and ERG Strategies, I've had predominantly positive relationships and interactions with commission leadership, staff, past and present commissioners. However, recent events have prompted this committee to reassess the CCC governance structure, which from an outsider's perspective is a necessary and prudent step. So when evaluating governance structures for cannabis agencies, it's crucial to understand two primary models. Again, what I like to refer to as the executive director model versus the commission or board model. The executive director model centralizes leadership in a single appointed leader, typically reporting to a high-ranking official, such as the governor, which was, in my case, in Maine. The executive director is responsible for all agency functions, including rulemaking, policy implementation, regulatory oversight, budgeting, and staffing. This model supports streamlined communications and fosters a cohesive vision for the agency. Key advantages include quicker decision-making, clear accountability, and adaptability, as one leader holds the responsibility for the agency's success and failures. However, this model places substantial responsibility on one individual, making the agency's effectiveness highly dependent on the appointee's capability to lead and execute the mission. On the other hand, we have the commissioner board model, utilizing multi-member board or commissioners to oversee the agency collectively. Commissioners, typically appointed by various government officials, bring a diversity of perspectives to decision-making. In this structure, the commission sets overarching policies, approves budgets, and makes high-level decisions, while a director or an administrator handles daily operations. This model supports balanced policymaking and shared accountability, though decision-making can be slower due to the need for consensus and multiple approvals. A further challenge is commissioners appointed by different officials may have varying priorities, potentially leading to fragmented policy objectives, diluting accountability, and a lack of cohesive mission and vision for the agency. You must have strong communications, coordination, and alignment among the commissioners, and most importantly, a strong relationship built on trust and mutual respect with the chief administrator, the executive director, and the staff. Each is essential for unified agency goals. Just to give you some national context, among the states with adult use cannabis programs, approximately 1/3 use the commission model, while the remaining 2/3 follow the executive director model. Each approach has unique variations tailored to each state's needs. Of the last 5 states to legalize cannabis, Maryland, Missouri, Minnesota, and Delaware have adopted the executive director model, while Rhode Island follows the commission model. Notably, Maryland transitioned from the commission model to an executive director model following similar legislative discussions when the state expanded from medical only to adult use. For foundation elements of success, in my experience, to build a successful regulatory agency, it's essential to incorporate foundational elements that foster accountability, adaptability, and transparency. These core principles create a foundation for the agency, supporting its mission, building public trust, and encouraging responsiveness to all stakeholders. You'll also notice independence is not on that list, as I often hear that as a foundational element of the CCC. I'm happy to discuss further after my testimony. Accountability is a cornerstone of effective governance in both the executive director and commission models. Need clearly defined roles and responsibilities are essential for ideal performance. Accountability means holding leadership, staff, and stakeholders to high standards and being willing to evaluate and address shortcomings in a timely manner. An executive director, this responsibility is clear-cut. They are singularly responsible for the agency's direction and results. In a commission model, shared accountability requires alignment across multiple appointees. The committee should avoid scenarios where the executive director and commissioners can hide from accountability while pointing to each other. Furthermore, who is the executive director and commissioners themselves accountable to? Is it one person or is it many? As far as adaptability, the cannabis industry, as we all know, is constantly evolving with shifting legal landscapes, emerging research, and changing public attitudes. To remain effective, a cannabis regulatory agency must adapt, ready to adjust policies, procedures, and priorities as new information and challenges arise. This adaptability requires quick decision-making and the ability to pivot strategies swiftly in response to industry developments. Whether led by executive director or commission, the agency must prioritize flexibility in its approach, figure out a way to streamline decision-making, and cultivate a culture that encourages proactive planning, timely adjustments, and continued improvement. And then the third one I have is transparency in decision-making. Policies and operations is crucial for earning and maintaining stakeholder trust. Clear communications about regulatory changes, policy decisions, and agency actions help stakeholders, including licensees, the legislature, and the public, understand the agency's objectives and processes. A transparent agency provides regular updates, shares data-driven insights, and establishes accessible channels for public feedback, ensuring that all agency activities are open and easily understood. The commission model is unequivocally better for transparency. However, steps can be taken in the executive director model to ensure a fully transparent agency. And then I think it's important that we talk about culture and the impact here. So in addressing recent developments at the CCC, I believe it's important to recognize culture is just as important as governance. Why is culture essential? Because it shapes how decisions are made and influences behavior when no one is watching. Any successful agency is built on strong culture with a clear mission, vision, and guiding principles. A leader, whether it be executive director or a unified commission, plays a critical role in embedding these cultural elements within an agency. The leader must also have the discipline to embody the mission, vision, and principles constantly. The agency mission serves as the rudder, providing direction, giving staff a clear understanding of their purpose, and guiding their actions and conduct. From my experience, a single individual setting the cultural tone is not enough. Nearly unanimous buy-in from agency leadership and its staff is also required. Unified leadership and buy-in ensures consistent messaging, decision-making, and actions both in public and behind closed doors. A leadership group or commission that lacks unity and struggles to find consensus on a way forward will hinder the agency's progress towards positive change. Any governance structure must consider factors that might lead to a fractured mission and vision for the agency. From my perspective, the most critical question here to answer is who's in charge at the CCC? Who sets the mission and vision? Who is accountable, for the agency's successes and failures? Having clear answers, whether it's an executive director or a collective commission or commission chair, creates an environment where a positive culture can thrive, and establish a clear understanding of accountability. When establishing and re-envisioning a cannabis agency, I think it's important to discuss and weigh the benefits and drawbacks of centralized versus decentralized models and determine which structure aligns best with the committee's priorities and Massachusetts' specific needs. In a centralized model, all key functions such as licensing, enforcement, communications, and policy development are consolidated within a single agency. This approach enhances coordination across regulatory activities and provides stakeholders with a single point of contact. A centralized approach can streamline operations and enabling faster response times and a more cohesive regulatory environment. Conversely, a decentralized model distributes these functions among multiple state agencies, with each agency focusing on specific areas. For instance, we see in other states, one agency might manage licensing and policy, while another handles compliance and enforcement. This model allows for specialized expertise in each area, potentially improving focus and depth of knowledge within each domain. However, it can lead to fragmented communications, inconsistent interpretation of the law, and may slow decision-making, as coordination across agencies can be time-intensive and resource-heavy. Here, I would argue, it's my opinion that a centralized model is ideal for cannabis due to the diverse needs and interests of stakeholders, the rapidly evolving nature of the cannabis industry, and a high level of scrutiny cannabis programs face in every state. So, in closing, I think it's important to remember there's no single right answer for choosing a governance structure. It's also important to note that the initial structure in which the CCC currently operates wasn't wrong. The committee, the legislature, and the commission have many successes in which they can point to. Much like the evolving industry, government can evolve too. Moving forward, what matters most to the committee, whether accountability, transparency, independence, or adaptability, requires balancing trade-offs within either the executive director model or an adjusted commission model. Through my nearly decade-long career in cannabis, I've learned cannabis policy is complicated and often over-engineered. The best solutions are usually the simplest. I'd like to note that once the legislature completes its work, the real work of implementing change will only begin. Organizational and cultural change is inherently challenging at the human level. It disrupts established habits, beliefs, and routines, and often creates resistance and uncertainty. To ensure success in addressing necessary changes at CCC, I encourage close collaboration with the commissioners, the new executive director, and the agency staff, not only during this process, but also in the months and years following any governance changes. Lasting success will depend on ongoing support, clear direction, buy-in from both leadership and staff, and a shared commitment to new objectives and goals. So with that, I would like to thank the committee for allowing me to share my experience and perspective. As you continue your work, I'm obviously here to support those efforts. As a former regulator, I understand the difficulty of these decisions and the challenges faced by the CCC commissioners, leadership, and staff on a daily basis. The Cannabis Control Commission has achieved much already, and I'm confident that there are more successes ahead. I wish the committee and CC all the best as you move forward. Thank you for allowing me to share my perspective, and I'm happy to answer any questions you may have.
Perfect. Well, thank you very much for your testimony. It's very insightful and wonderful to have different perspectives. I think we'll turn over to co-chair or to any committee members that might have any questions.
I had a question.
Yeah, absolutely.
Thank you for your testimony, Senator Gomez here. In your opinion or in your expertise, you had spoke a little bit about the executive director model. Under the executive director model that some states are doing versus what we do here in Massachusetts, who or is it upon the executive director to make regulatory changes, or does that always rely on whenever in the industry some changes need to happen, does it fall on the legislature to make those changes?
I think there's a shared responsibility there. I think really the mission of any agency, if it's led by an executive director, is first and foremost to protect the public's health and safety. But I think we're starting to understand more and more part of the responsibility is to cultivate and create a competitive environment for these legal businesses to compete. So being a thought leader, I think more than just issuing licenses or taking administrative actions against penalties or administrative actions for non-compliance. A lot of these agencies, executive directors, and even commissioners in the commission model should be thought leaders in this space, and find ways to improve the program through either putting forward legislation from the agency or updating the rules. But laws are made by the legislature, and I'm sure Massachusetts is much like every state. It seems every legislative session there's dozens of cannabis bills. I think the most important part here, if you're talking executive director or even the commission model, is just a positive working relationship and making sure that there's communications between both the legislature and the commission in Massachusetts or the Office of Cannabis Policy in Maine, as those folks are the ones on the ground doing the work day to day. So I don't know if that answered your question, but I certainly hope it did. I'm happy to expand upon any part there.
No, I just, if there was a change within, I guess, Maryland's model, if I heard your testimony right there, they went from a commission model to an executive director model, that if there was maybe a change within the industry that had to happen, did it rely or did it happen on a regular? So the reason for my question is because there is a difference of opinion from community that things that are statutory that the legislature has to make changes for, and then regulatory things that the legislature feels that the commission can make the decisions on creating those changes. In that, I would say, because I'm fairly interested in, your testimony in the executive director model. Obviously, we have a different model to understand if the executive director wholeheartedly has the power in that industry within Maryland or those other, or Delaware that you had stipulated, to make those changes that didn't need statutory change, that maybe if it was weight limits on what you can buy or what you can sell, or that solely just respectfully had to always go back to the legislature to make changes. And like you said, like if they had to change the rules or of some sort.
Yeah, no, I understand the question better now. Thank you. It would fall on the executive director. If they have the statutory authority to make whatever changes needed to address whatever changes happening in the industry, that would fall on the executive director to be able to do that. I think that's an important approach for timely action. If there's a pressing need or issue for a regulatory adjustment, a rule adjustment, waiting for a legislative session might not always be the ideal scenario, right? So giving the authority to that executive director and the agency to make those changes, I think is incredibly important. The second thing I'll say though is while those executive directors are the sole authority in cannabis and really the vision and mission and the policy, in my case, I had a long leash, but I was also accountable to my governor. So I wasn't making larger decisions that would impact the program in a silo. I knew what items that I needed to bring to my governor to make sure that she was looped in and understood and she was supportive. And I knew which ones that I was able to make without elevating. So there's that piece too, but it would be my opinion if there's adjustments needed to the rules and the authority is inherent in the law, that the agency or the executive director should be the ones that are able to make those certain changes.
So and lastly, in your opinion, regardless of the executive director model or the commission model, that regulatory changes could be made or should be made by the executive director under the guidance of the guise, obviously, of working with the governor or with the commission, which the commission are able to make those decisions, obviously, within a democratic way, because obviously we have 5 appointed individuals, or 4 at the moment. All right, thank you.
Yeah.
Thank you.
Correct.
Thank you so much.
Kind of just build on that. You mentioned a little bit during your testimony as well, but the idea of independence you had brought up, the idea of not, you're saying you're accountable to a governor. We're talking about regulatory decisions being made outside of legislative action. So why were you leaving independence off the list, or how do you find an agency's independence helpful or detrimental to maybe their regulatory abilities?
Well, again, these priorities are unique from state to state to state, right? And as I said in the closing of my testimony, the current model in Massachusetts wasn't wrong. It was right. And there's a lot of successes that can be pointed to and hold Massachusetts up as a leader in cannabis. Independence, to me, I guess, what are we trying to be independent from? Are we trying to be independent from industry influence, changing public attitudes, shifting political winds? I would say even in a commission model or an independent model, you are still subject to some of those things while giving up some of those other pieces that I highlighted. So that's when I say it's a give and take. I think it's important for this committee to understand, all right, here are our top 2 priorities, or here are our top 3, here are our 4, and here's how they ranked. Then you can kind of naturally back into what either moving all the way to an executive director model, which would be a significant shift, or making some smaller adjustments to the current model. There are things that you can do to improve accountability or improve the culture, or, I mean, Massachusetts, from an outsider's perspective, has always done a fantastic job with transparency. When I was running the office in Maine, I always was trying to keep up with the data transparency on the website and try to outdo the CCC and their stakeholder engagement, having those conversations. So I've always felt like Massachusetts has really led in that regard. But again, it just comes back to the accountability. Who's setting the mission vision? Who's the leader that is getting everybody bought in and is accountable when there's successes and is accountable when there's failures?
Excellent.
And that's both internally and in a policy regard as well. So
Yeah, thank you. Representative, sorry, I just want to introduce, I did see, we have the vice chair on the House side, Representative Consalvo from Boston, and Representative Don Shand is also with us as well. So Representative Sauter.
So I just want to be clear on Maryland. Doesn't Maryland still have the commission as an oversight board?
I believe Maryland does have an oversight advisory board or advisory commission, yes.
So-
but I don't think,
It's very similar to what a finance committee would be to a town, local town, correct? Almost.
I don't know what a finance committee would be to a town. I believe, and I would want to double check and get back to you, make sure that I have the right answers here, but I believe the oversight committee has the authority to provide recommendations to the Maryland Cannabis Administration.
Okay. I think, I guess my question is, I understand what you're trying to recommend to us or tell us in the sense of what's going on and give us some perspective on things. And because I'm hearing 2 things in your testimony, that we do things better than some, and we don't have clarity on who's in charge. I guess in your experience, there's one thing that you didn't address, and I'd like to see if it's different under your model of just an executive director or a commission model. Is the council that counseled you in Maine an independent body that you appointed, or an independent body that statutorily was appointed to advise you?
First I want to address, if I have come across in my testimony as recommending or pushing an executive director model, that was not my intent.
Okay, thank you.
My intent is to kind of shine the light on the pros and cons of each, understanding that the commission model has worked and has worked in many different states.
Okay, great.
Second, so Maine, I did not have a commission or council above me. I reported directly to the legislature. We, much like Maryland, had an advisory council that would get together, talk about updates to law, regulations, the operations of the office, and again, provide recommendations.
So you had no legal counsel, general counsel in your office advising you on the laws that were passed by the legislature? Did you have a general counsel in your office? Do you have attorneys in your office advising?
Yes, we had attorneys in our office.
Who
and we were also
appointed those
assigned-
attorneys? You? Did you hire those attorneys, or were they statutorily an independent general counsel that was appointed?
They were assigned to our agency from our Attorney General's office.
From the Attorney General's office. So they were,
Yes.
you could say they were independent, advising you on the laws that were passed by the legislature, signed by the governor. It's
Yes.
fair to say, okay.
Yeah.
I guess my question is it fair to say when you were looking at our when you're looking at our setup that we have here with the commissioner base and executive director, I mean, I kind of feel that the executive director does have a lot of autonomy to do a lot of things that you stated, even with the commission. I think our commission and our model is very similar. You might not know, how Massachusetts is set up, but we have a lot of municipalities, we have town councils, we have city councils, et cetera. So it's kind of set up in that same model. So I guess my question is, it seems to me like our executive director has that. I think the biggest struggle is either we're not appointing the right commissioners to work in balance with the right executive director, or their executive director feels like they have so much autonomous power that they can do whatever they want. So I guess when you're looking at it from that perspective, we're talking a lot about changing and changing the model. I'm not necessarily sure I would be for something like that or recommending something like that moving forward, but because I think if we go to an executive level position, I think we create a lot more bureaucracy than we need to. I guess my question is, when you analyze what we're doing, what are some of the complications and hurdles that you have seen? You said in your testimony that we do a lot of things well. Is there anything that you saw in the current setup that we currently have that we do well?
I think I love the idea of bringing in a diverse expertise of the commissioners. I think that's helpful in the discussion around policy development, around how to actually administer the program in Massachusetts. I think that is a clear benefit of the commission model, and at least in my experience as an outside perspective, has brought a lot of benefits to the Massachusetts program.
Okay. I would just, one thing I'd ask the chair, that really didn't answer my question, but what I would do is ask the chair, because I don't want to take up too much time, if you could provide us with things that you see a positive in our current setup that are positive things that we have in our current setup that we have in our negative. Give us the positive and the negative. You can't obviously do it in the amount of time that you have to talk and the amount of time I have for questions, otherwise we'd be here all day, and I know the chair doesn't want me to do that. So I would ask that if you could actually give us kind of your outline in your professional perspective, and from being in a different state and running an agency like this, give us some pros and cons and some hardcore facts that we can look at and say, oh, we didn't see that. Oh, that's good. Let's build upon that, because that is a roadmap, and that's what I'm trying to get out of all these hearings today. Is, I hear everybody coming up here and saying, oh, you do this good, you do that well, you do this good. Well, then we wouldn't be here if we were doing that many good things, right? So we're not. So let's figure out what those things are, and I would ask the chair if we can get those, because I think it would be a great read, and then we can go back with more questions. So thank you, Mr. Chair.
Thank you, Representative. Questions from the committee? Yeah, Representative Saunders? Oh,
Thank you, Mr. Chairman, and thank you, Mr. Gunderson, for your testimony. I have a couple of questions regarding the current statutory scheme for the commission in Massachusetts in the context of not so much the personalities that have been mentioned in the media from time to time, but how the best possible structure could be attained. So currently in Massachusetts, and it's been put on display on an almost daily basis, we have a fairly complex standard for both appointments and dismissals. We have 3 separate appointing authorities who appoint on their own and then together, and the standard for dismissal is easily readable, but apparently not as easy to implement. So I'm wondering what your thoughts are in terms of how you see appointments to commissions occurring in other jurisdictions, as well as the dismissal standards.
Yeah, no, I mean, I'll start with the dismissal standards. I mean, it's important to make changes if the agency is not performing it in whatever regard it may be, an individual on the commission, an individual on the staff, leadership within the commission, whatever it may be. I'm not exactly sure what the details are of that process, but I could tell you if I was ever not performing or causing negative outcomes at Maine's Office of Cannabis Policy, I would imagine that I would be removed immediately. and had the same authority. Obviously, you have to work within the bounds of state law and HR processes. But if there was individuals within my agency, as the executive director, I could take steps to remove those individuals as long as I had a justification for doing so. With, I don't want to say minimal hoops, because there are standards and things you need to do in order to make sure that you're going through the right process. But those are decisions and changes that could be made if needed to be made. And as far as the appointment question, I would say, I think I addressed it at the very end there, saying cannabis policy in the administration of a cannabis program is complex and difficult and challenging and can be often over-engineered. I found that oftentimes the simplest answer is the best answer. So when you're talking about all the different individuals within Massachusetts that, I'm assuming this is what you're asking, the authority to appoint those commissioners, I understand why you would do that. I understand you're trying to, I think that ties into the independence of it. I understand that there's also a conversation around political feasibility to get some of these things passed at certain times. Everybody needs to have their role. But I think, again, a simplified approach, if that's what the committee would decide moving forward, could result in some benefits.
In your experience and maybe familiarity with states and jurisdictions that have the commission model, how common is it to have commissioners serving at the pleasure of the appointing authority, where that appointing authority is free to dismiss the commissioner with or without cause?
I think that's a best practice. I think that's typical. But having said that, this is another one that I would like to go back and take a look at some of the states to make sure that I am not giving you bad information.
I appreciate that. And then my final question, with regard to the executive director models, you mentioned in Maine you reported to the governor. Is that typical? For example, the Alcohol Beverage Commission in Massachusetts reports to the treasurer. Does that vary across the country, or is cannabis generally held within the governor's book of business?
Typically held within the governor's book of business. If the agency is vetted within state government, I reported to our commissioner at the Department of Administrative and Financial Services, absolutely wonderful human being and leader. But when you're talking about cannabis, it's widely known that cannabis is under a microscope, and often a lot of the accountability goes directly up to the governor. So yes, while I certainly reported to a commissioner who basically cabinet level, a lot of the conversations were had with the governor in the governor's office.
Okay. Thank you.
Excellent, thank you. Any other questions from the committee? I think we'll move on to the next host. Thank you so much for your testimony. We truly appreciate it. It's a great, interesting perspective on a couple different levels. And yeah, if you have any additional information you can share with us, we can certainly get it out to the committee members that was requested. But we truly appreciate your time and truly appreciate the perspective that you brought. So thank you very much.
All right, thank you. Best of luck.
Thank you. All right, we're going to return to Professor Landers, who is joining us. Hi, good morning, Professor. How are you?
Good morning. I'm well, thank you. I apologize for the technical difficulties before. But,
no worries at all. I think we're all used to technical difficulties these days. So we appreciate you sticking with us, and we appreciate your testimony whenever you're ready. Thank you.
All right, good. Well, thank you so much for this opportunity. I really appreciate it. And first I want to say that I think that your previous speaker really did set a very good kind of theoretical stage for how to think about, some of these issues. I would also endorse the first thing I would say about all of this is that there is no one right answer to some of the challenges that are confronting you in your efforts to make sure that we have the right regulatory structure for cannabis in the Commonwealth. That there are, many possible structures, governance structures that could be successful, and finding out sort of maybe this process that we have here needs some tweaks, or possibly maybe some changes in some of the authorizing legislation about what the scope of the responsibilities is for the commission, might be another way to think about it without necessarily changing the structure. And the thing I always say, I teach administrative law, which is why I've been asked to, I think, testify today. But the thing I always tell students when I'm teaching administrative law is, first, there are no right answers. There are a variety of choices, depending on what the goals are. And second is that regardless of the structures or the government's constraints imposed on any kind of activity or government entity, often it comes down to who the people are. Are the people working within those structures with an attitude of good faith and adherence to the mission and adherence to the accountability to the public, or are other issues diverting them from that task? And I think your previous speaker was also correct in noting that, with regard to this point that I'm making about who the people are, that the commission, until fairly recently, seemed to operate without controversy and with a lot of efficiency in actually standing up a regulatory structure for cannabis in the Commonwealth, and only recently have some of these complications emerged. So I would say a couple of things. I kind of endorse a lot of the structural comments that the previous speaker made, but I wanted to focus on a couple of things. First of all, in the charge, I think it's the charge to your committee, or the committee that the outline of work that you announced, I think you noted that there seems to be some tension between the responsibilities assigned to the commissioners, and particularly the commission chair and the executive director of the agency. I think that you were asking the previous speaker about what things should be done by statute, which things could be done by regulation. I think actually maybe one of the things that would benefit from your attention is really clarifying that, that seeming, assigning essentially the same oversight responsibility to at least the chair, if not all the chair plus all the commissioners, and then the executive director, because I think that overlap kind of sets up opportunities for conflict and disagreement, where perhaps a clear delineation of what the boundaries are between the commission and the executive director would be more effective, especially if you were keeping with the commission model. A second observation is that, I was looking at some of the materials that are publicly available about the efforts of the commission to address some of its governance issues. And I was looking at the, proposed charter of operations, which is very thoughtful in its level of detail. But there seemed to be in that document a little bit of a setup of an us versus them kind of scenario, where the commissioners are the commission, and then there's the agency staff, the administrative staff, including the executive director and the staff. And I think that kind of disabusing people of that notion is really important. That it's that regardless of whether you stick with the commission model or move to some different kind of structure, the agency is the agency, one whole agency, and should be devoted to a singular mission, or sets of goals that the agency is trying to achieve, and not have this kind of tension and competition between the commissioners and the agency. It's not the same as your oversight role, which is a little bit more restrictive and which is really an oversight role of the executive branch. But that's not what should be happening at the agency. There should be oversight, but they're all one agency that should be trying to move toward a singular set of goals. So then going to, some of the issues about the structure. There are examples of state agencies in the Commonwealth that work very well, where the commissioners are appointed, the members of the commission are appointed by different appointing authorities. And in fact, as I mentioned earlier, this commission seemed to function pretty successfully for a period of time. So I'm not sure that that's inherently a structural defect, but I think, as the previous speaker noted, that one of the concerns raised by that structure is the accountability concern. If there is one appointing authority for the commissioners, or say an executive director, then the accountability lines are pretty clear. The appointing authority is the appointing authority, and that person is able to take some action if things aren't going well or are not, proceeding, quickly enough, whatever the issues are, that could be as an easier path to addressing those if there is one accountable elected official. So that's point number 2. So I just think it adds a layer of complexity, but it doesn't necessarily mean that it can't be successful with the right level of cooperation. Although, now, where does the right answer to quote unquote fix things lie? And so having a singular appointing authority would perhaps make that addressing that problem somewhat easier. But as I said, no right answers. It's just one thing that could simplify various actions. You were asking the previous speaker about the difficulty in removing commissioners if you were to stick with that model. So, first of all, for all the employees, the executive director, there are all kinds of perhaps due process protections that apply, for state employment. However, for the commissioners, this standard for, that the commissioners can only be removed for cause, does create some barriers. And that is, I think, an effort by the legislation, the governing statute, to try to create some measure of independence for the commission. I personally think that the value of independence perhaps is misplaced in this context. Because I think that, what's required here for a commission like this one is a real laser-like focus on public health and public safety in all aspects of the operation of the cannabis industry, and to administer a licensing and a disciplinary scheme that has the confidence of the public. And so I think, the independence of the agency from political oversight would seem to me to be a secondary consideration in this context. However, if you're going to have an independent commission like this one, I think that these kinds of standards on removal are very common. They're very common at the federal level, although that, the court decisions are eroding that somewhat, and they're very common in state government as well. So I don't think that's necessarily a huge difficulty with the current structure. But again, it all depends on getting the right people and getting the agreement of the appointing authorities about kind of what the goals of the commission are. I would say that one feature that is really important about who the commissioners are and their term of service is the term limit, is the time limit on the term, right? And so I did notice that several of the commissioners, many of the commissioners, are coming up at toward the end of their 5-year appointment term. So in that regard, this might be a good time, if you're going to change the structure, to do something about it, because the people have no right to be reappointed to these jobs. And if there are problems, sometimes the easy path is to just fail to reappoint people instead of, allowing them to continue on. You don't have to terminate them. You don't have to find cause, but you can, decide to move on to someone else when it comes to the end of their term. And so I think that that's an important feature to keep in mind, that maybe there should not be a presumption that a person would automatically be renewed in their appointment as a member of this commission. Let's see. I just wanted to address, I don't want to speak for too long, and then I'm happy to try to answer some questions. One of the other things I noticed is that on the standards in this governing charter that the commission has been working on, that there seems to be a lot of opportunity for the commissioners to kind of get complaints from the public and then kind of pass them on to the staff, and to try to, to have sort of these bespoke or these ad hoc kind of processes for dealing with complaints from the public. And it's particularly concerning in the conduct of the investigation of complaints or, allegations of violations of the law by licensees. And I think that's particularly concerning in that context. So I think that, one of the things in the charter was that commissioners were to be encouraged to keep a log of all these contacts from the public about these sorts of things. I just think that the commission really ought to seriously consider just not allowing that, to set up a formal complaint process that's outside any individual interpersonal contact with individual commissioners, and to rely on that formal complaint process. And maybe the commissioners could file, could make some recommendations and things like that about issues that need to be investigated. But I just think that kind of thing should stop, especially in the context of investigating violations of laws. And I noticed that the commission's charter says it should stop as soon as a licensee or anyone has requested a formal adjudicatory hearing under the Administrative Procedure Act. But I think the best practice would be just not to have that kind of stuff going on. And then in relation to that, I think that there should also be really a much more detailed accounting of the investigatory activities and enforcement activities of the commission. How many complaints were received, how many investigations were initiated, what the source of the complaint was, and then the result, the disposition of those complaints, whether the commission decided that it was not meritorious and dismisses it, whether there's a negotiated settlement, or whether there is some kind of enforcement action that was actually taken against the licensee. I think those kinds of things should be publicly available, and because first of all, it's information to the regulated industry about the kinds of things that will get you into trouble and what the commission will do if that happens. And second, it's a way for the public to understand that the commission is actually doing its job and taking public health and safety recommendations effectively. Then the last thing I will say is on this public health and safety question, which was touched on at one of the earlier hearings that you had. I think for all the reasons that the previous speaker stated, it is the most important function of the commission because of the scrutiny under which the industry operates. Everything that goes on here still is not lawful under federal law, and I have an opinion that what we're doing is the way the issue of cannabis should be approached in society. But it's still that, and therefore there's just going to be a lot of scrutiny about licensees, what happens in communities, and the conduct of the commission. And so I think that focusing laser-like on public health and safety, the integrity of the products, worker safety, having this complaint process to take complaints seriously, all of that should be really front and center of what the commission does. I recognize that the social equity component is a very important public goal and signal to the public. But I think that needs to be balanced with this laser-like focus on public health and safety, the testing of products, and to make sure, and setting standards for products so that the public can have confidence in them. So I'll stop there, and I'm happy to answer any questions.
Thank you very much, Professor. Appreciate your testimony. I'll turn it over to Co-Chair. You have questions? Any questions from the committee? Any questions? No? Yes, Representative Saunders. Oh, wait.
Thank you, Mr. Chairman, and thank you, Professor Landers, for your testimony. I have a couple of questions in the context of the way the Commission operates currently, and along with the proposed governance charter. And I'll say, as one member who has tremendous respect for the separation of powers, I appreciate you drawing the delineation between the role that this committee plays in an oversight function of the executive and how individuals within the commission are responsive and responsible to one another. One of the concerns that we've heard raised from time to time is the claim that the current statutory language may be at best ambiguous, at worst contradictory with regard to the responsibility of the commission versus the responsibility of the executive director. From a best practices perspective, do you find it to be desirable for the commission to be effectively at the top of the pyramid, and for that executive director to respond and be responsible to the commission? Or conversely, should the executive director in a commission model have any independent authority?
I think that having the executive director have independent authority, well, it depends on what the range of independent authority is, but certainly from the policy-making function, it seems to me that the commission should be in charge and should drive the bus. That I think I just don't see how it's workable otherwise. I think that the executive director could have some independent authority about administering, oversight of the staff, managing the staff, managing the investigation and enforcement process, but all under policies, and with votes of the commission endorsing what some of those activities are. And so I think if you're going to have, I think it makes it very complicated to have two competing power centers. And I think that the traditional model would be to have the executive director reporting to the commission.
Thank you. And my second question is with regard to the establishment of regulation. So in Massachusetts, we have a very thorough process for establishing any type of regulation anywhere across the executive. What are your thoughts about a document like the proposed governance charter standing in the place of, both from a procedural perspective and from a substantive perspective, standing in the place of the place where regulation ought to stand?
I think that its legal status would be unclear, and I think it has the possibility for confusing things. So I don't think the charter would necessarily have any legal enforceability. I think it's I took the charter as kind of a statement of we as human beings, this is how we'll agree to deal with each other. But I think that the statutes and the regulations about procedures, for investigations, complaints, procedures for rulemaking, all, which are governed by law, as you said, all of that, that is the law, and these other things over here are kind of like our practices for dealing with each other. So I really don't think, I think the charter might be helpful in interpersonal relationships, but I don't think it takes the place of the law.
Thank you.
Nor should it.
Thank you, Mr. Chairman. Thank you, Professor Landers.
Any other questions from the committee? Any other questions from the committee? We good? Well, I have a couple quick follow-ups, and really appreciate your testimony earlier. And just kind of one of the things I know you were just talking, Representative Saunders, about some of the governance documents and things, but you had mentioned a little bit about simplifying some of the decision making through a single appointing authority, and bringing that kind of into line. And one of the concerns we hear over and over again from industry folks, and we heard in a hearing before this where we invited stakeholders from the industry to come testify, was kind of the complex and sometimes slow process of getting regulations heard or pushed through. Does even bringing in a single appointing authority or kind of removing some of the independence help to simplify regulatory decision making? We're trying to find other avenues, other regulatory schemes in different industries that are similar to cannabis that seem to be able to be a little more nimble in their ability to bring about regulatory change or to kind of change some of change their ways as the industry changes. And I don't know if you could speak to that a little bit more.
Well, I mean, I think the first fact is that the regulated entities always think that the process of change is too slow. That's a common feature of the system. But I do think that the problem that you have with the multiple appointing authorities, it's actually a two-stage problem. There's the problem of the multiple appointing authorities, although it's not clear to me that beyond, actually appointing the people, any of the appointing authorities, kind of take direct, kind of accountability or responsibility. And I'm not criticizing for that. They appoint the person and then they see their job is done. And I can understand that approach. And so if you had a single appointing authority, I think that person might have more of a stake in what the commission does and its responsiveness, right, to the public and to the industry. Second, the other problem is that the commissioners all have their separate kind of mandates, their expertise mandates, their experiential mandates, and I'm not arguing that against having all those points of view and those experiences represented in the decision-making process of the commission. But I think that it sets up this idea that these commissioners should be advocates for that point of view, instead of like we're all in this together trying to create a comprehensive and cohesive regulatory scheme. And so I think that that's kind of a harder problem to solve in a way than who are the appointing authorities, because I think you need to have the people say, well, yes, I was appointed because I have this expertise, but my real job is to take into account what my colleague is saying about, social justice or public safety, as well as what I think about, what the industry really wants to have to kind of ease the path. So I think there needs to be that recognition that it's the mission of the agency that these people need to be pursuing, and not these separate, perhaps, advocacy goals of those components of the stakeholder community. I don't know if that answered your question. I feel like I'm leaving out a part of the answer to the question that you asked.
Yeah, no, I think that's very helpful. I think it builds upon a little bit of that us versus them mentality you kind of were mentioning before. How do we kind of build a more cohesive mission focused, I suppose. And maybe build on that a little bit, kind of speaking generally. I know you're, with your expertise, kind of administrative law. Is it unique or different, I guess, or how often do you see regulatory schemes like cannabis, like as we're talking about here, changing, the structure changing over time. Like as far as, the idea of, we've approached one problem with this regulatory scheme or with this setup of this enabling statute. Now we're going to approach it in a different way. Is this something that you see in administrative law often?
Well, I don't know about often, but I mean, change does happen. And I think it's a good thing if people look at a structure or a whole set of regulatory requirements and say, this isn't really working anymore and we need to change and we need to have adaptability. I don't think that's a bad thing. So I don't think you should feel like it's this, out of the box, really highly unusual thing to make a structural change in the way things are governed. So I can give you a couple of examples, and this was the part I was thinking that I wasn't answering sufficiently a minute ago. So we have, a couple of really big new agencies on the federal level, right? We have the Consumer Financial Protection Bureau, and we have, the Department of Homeland Security, different scales, I recognize, which didn't exist, which, the Homeland Security is, a little, just barely 20 years old, and the CFPB is even more recent in its origin. And it was I'll just take the CFPB because that's, just like, focused on a particular industry, consumer protection and the, financial services. And, because the existing regulatory structures, the banking industry, whatever other elements there were not really focused on that protecting the consumer mission. And, our Senator Warren, this became one of her, signature ideas that we needed to have an agency that was focused on that. And I will point out that agency has a single head appointed by the president, and the staff works for that executive director. I'm not saying that's the only model, but that's one approach. Another area where I think you could look at is the Food and Drug Administration, right? So, its mission is to make sure that the drugs and devices that go onto the market that the public uses are safe and effective. Its mission is not to promote the pharmaceutical and device industry, right? And so that those are secondary concerns. They recognize that they have to have an efficient, credible regulatory process so that the industry isn't kind of always left hanging when they're trying to get products approved. But the goal is not promoting the industry. The goal is to protect the public. So I think that's another option, example. And then a third, which in my view works somewhat less well, but I don't know really enough about it to say for sure, is the Department of Agriculture, the USDA, because it does have this food safety component, but it also has this, we're going to promote, the agricultural products of the United States component. And sometimes those components might run into each other, right? Keep pleasing the industry and keeping the public safe are not always consistent goals. So I think that's another example where an agency tries to do both, and maybe having some separation is a better idea.
Excellent, thank you. Well, seeing no other, Representative Shand.
Thank you, Professor Landers. So to me, your testimony is so interesting. We have an agency, on the one hand, where we want to see it grow. We want to see the businesses thrive. And they feel that the regulations are standing in the way of their business success. On the other hand, there's a public safety and public health dimension that often feels at conflict with the agency. We're promoting smoking, is one example. So, I find this quite challenging. And I wonder if you have any advice for us about agencies that have essentially oversight for both economic growth and public health. Plus, it's, as you said, it's illegal at the federal level. And we have a strong desire to right some of the wrongs of the war on drugs. So how do you help us think through conflicting strategic prerogatives?
I think that's a big challenge. So I think one possibility would be to think about putting those different functions in really different buckets with firewalls in the agency. Another option might be to, particularly on the, promoting this, the promotional activities about promoting the industry. I mean, maybe those belong in some other agency, that's about promoting, Massachusetts business and industry. I don't know. I mean, I've been thinking about, the life sciences industry a little bit in this regard. And, the difference there is, it's fine for Massachusetts to have this totally promotional approach to life sciences industry because, as I mentioned previously, there's all this federal regulation that takes care of all that health and safety stuff about what they do. And we're sort of, the state is coming in kind of after the fact and saying, well, if you have these products that are really excellent, or if you're, we're going to help you research and produce more products, but it's not our concern. Other people are taking care of that health and safety issue. And if you have that product, then we're going to try to make Massachusetts a great place to do the research and make the products, right? So, I think, trying to figure out ways to separate those functions, I think might be a really good thing to do. For example, some other law enforcement agencies have both kind of an advisory and an enforcement function, and that, you really try to separate the two activities. And then when the issues come up to, say, the commission or the executive director, that's the point at which, people try to achieve the balance.
Thank you so much.
I think it's, yeah.
Any other questions? Well, seeing none, thank you so much, Professor. We truly appreciate your testimony and answering our questions on all kinds of different fronts.
All right, thank you so much. I appreciate the opportunity to think about this. And if you have any other further questions, or if I can be helpful in any way, please don't hesitate to reach out.
We appreciate that. Thank you very much.
All right, bye-bye.
I'd also just like to say Representative Sousa has joined us. Thank you for being here. All right. Moving on to our next testifier, we have Professor David Hammond, who's going to be joining us. Professor, thank you very much for joining us.
My pleasure. Can I just confirm that you can see and hear me okay?
Yeah, we can see you, and we can hear you, and we can see your presentation. So I think
super wonderful.
Good. Want to just introduce yourself and then start with your presentation? That'd be great.
Sure. My name is David Hammond. I'm a professor in the School of Public Health, and I come from Canada. And I've been asked to share with you some of our sort of alternative models to regulating cannabis. So just before I begin, I have no industry links or interests. I have no political affiliations. And as you know, you could probably get many different answers to the questions that you're asking, depending upon who you're asking. I'm going to talk today from sort of a public health regulatory perspective. And as you may or may not know, Canada legalized what we call non-medical or adult use cannabis in October 2018. So we're about 6 years into the process. And one thing you will know from your experience is that when we talk about the structures and legalization, the answers differ depending upon each year. And a lot has changed in Canada, both in terms of the market and in terms of how we regulate it. And when we talk about Canada, I just want to clarify some of the differences between how it's regulated up here and down in states like Massachusetts. First of all, we have federal legalization, but most of the rules in terms of the market are actually implemented at our provincial level. So that would be your state level. And it's fair to say that in most cases, Canada has more strict or comprehensive rules or regulations than most or all US states. And that's true whether you're looking at product standards or warnings or greater restrictions on marketing. We do have a lower minimum legal age in most provinces. But generally speaking, we have a more restrictive legal market. And one of the other big differences is that every one of our provinces is directly involved as a wholesaler distributor of cannabis. So all the products go through the government, who then distributes them to the stores. And in some provinces, those stores are all private commercial operations. In some provinces, there's a mix of actually government-run stores and private stores. And then we have 3 provinces where every retail store, you buy it through a government-run store. So these are some differences in our model. Now, I think some of the questions that I've heard you asking today are probably more specific in the process and structure of how agencies are constructed. And that's not really my area of expertise, but I can tell you that when the general structure in Canada is, of course, we have those federal laws and regulations. Each province, or in your case, state, can implement additional laws and regulations. They're mainly responsible for the retail market, and that's done through the typical legislative rulemaking process. But it's interesting that in most of our provinces, we have separate government agencies. A separate agency that's responsible for sort of implementing and enforcing regulations, issuing licenses. And then we also typically have a different agency that's got the commercial mandate, which is to actually distribute the cannabis and in some cases sell it directly. So I live in our largest province, the province of Ontario, and you have 2 different agencies. You have the Alcohol and Gaming Commission of Ontario. It has a board of directors, the CEO. It reports to the Attorney General, and its responsibility is to implement and enforce regulations. Within the same province, you have what's called the Ontario Cannabis Store, separate board of directors, separate CEO. They're the ones that are responsible for the wholesale and direct retail sale, and they report to the Ministry of Finance. So you actually have these sort of dual structures, and the idea is that they have distinct mandates and responsibilities. Now, there was a really interesting question and discussion a minute ago about balancing the commercial and public health interests. I think that's a question that every single state, every single province and country that's done this so far has debated. And I think each jurisdiction has landed on a different balance. Ostensibly, public health, trumps commercial interests in many of their regulatory objectives, but that may not be reflected in the market. We have different balances in different provinces. Our second largest province in Quebec has much more of a balance on public health than commercial interests. And what that means in practice is essentially stricter rules. So all the stores are government run, mainly because they have concerns about what can be sold and how to do that responsibly. They have a higher minimum legal age. They have far fewer stores per capita. They have even stronger marketing rules than the federal rules. And they have the strictest product standards of any jurisdiction. What is that? I've been asked to say, well, what does that mean in terms of sort of patterns of use? Well, the short answer, and I don't want to get into the numbers here, but it's meant that the prevalence of cannabis use in Quebec, where they have the stronger rules, has remained lower and changed at a slower rate than it has in the rest of Canada, whether you're talking about use in the past year or daily. Now, just to flesh out what I've just said, just to illustrate the differences in our different market. In Quebec, where they run all the stores, they have about less than 1.5 stores per 100,000 people. You can see that's almost 20 times greater in some provinces where there's more of a private model. For example, our province of Alberta, where there's more than 20 stores per 100,000 people. So that's one of the consequences of having sort of more of a public health focus. It's also meant that, as I mentioned a minute ago, that there's stricter rules on some provinces. And so in Quebec, they actually have a THC limit of 30%. You'll have a hard time finding any vape with less than 30%. And in fact, they don't sell any vapes at all in Quebec. And it's somewhat laughable, but Quebec has decided not to sell any edibles that might appeal to kids. So in Massachusetts, as is the case in most of Canada, you've got chocolates and gummies, brownies that are your leading edibles. Well, in Quebec, if you don't speak French, this is dried cauliflower. And they sell dried beets and other things because they refuse to sell candy-related edibles. A big question about these different approaches, and part of that balance between commercial and public health is What types of rules may sustain illicit trade? And you see this come up a lot when there's a discussion of THC or strength limits. I can tell you that in Canada, we've seen very steady increases in legal sales. So this is essentially all the legal sales in Canada. And you can see that it has increased almost in a linear way from the start of legalization. And in fact, this increase has been very similar across our different provinces. Too much here for you to grasp, but what I'm showing you here is that the transition to legal stores has been about the same in Quebec, where they have stricter rules, as it has been in some other provinces. In fact, the main drivers of how many people have shifted to the market has been the price and the retail accessibility in the early days, not so much the product standards. I'm going to wrap up here, but I just wanted to say that we've been tracking what consumers and the public think about this balance and the differences between private and government-run stores. And what we see is that most people, most of the public is quite supportive of stronger rules. In fact, we see most of our cannabis consumers say, yeah, I think Canada's strong rules on advertising, for example, are about right. And you have about the same number who would like more or less advertising. And I can tell you, we've been tracking this in Massachusetts and other US states, and it's about similar. So there does seem to be some general public support for sort of stricter rules. The last thing I'll mention is just I've been asked to comment on how the structure has evolved for supporting surveillance and research. And I will say that virtually all jurisdictions and provinces in Canada have struggled. We typically don't have enough detailed surveillance. By that I mean both what's happening in the market, but also what's happening at the population level in terms of who's using what. There's struggles with getting the same data over time, and as may be the case in Massachusetts, there's huge interest in one province and what's happening in another province with different rules, and I know that's true in many US states. So there are a couple provinces that mandate some of the tax revenues to be invested in research. That has helped, but I think this challenge is by no means unique to any one jurisdiction. And I'll just finally point out that if you are interested in a pretty good summary and overview of what's happened with legalization in Canada, there's an official review of the first 5 years that's publicly available and is quite informative on a wide range of issues. So I'll just say thanks very much, and I'm happy to answer any questions if there's time.
Excellent. Excellent. Thank you very much, Professor. Appreciate the presentation, and definitely make sure we take a look at that document afterwards as well. But any open up to questions from the committee? Yeah, when we talk a little bit, actually, I want to expand on Representative Shan's point about, you know, the unique nature of cannabis, of both promoting the industry as well as controlling for public health. And kind of, you know, what we're looking at here is a lot of the, you know, we have some internal conversations and issues around having a regulatory structure that's responsive to the needs of the industry and a regulatory structure that's sometimes purposely slow to ensure that we're giving some thought to it. So kind of in some of your experiences, some of the provinces you've seen, how is the speed of regulatory change kind of weighed with the benefits or hindrances to public health?
Well, I'll say the first thing is that change has been essential in every jurisdiction. I don't know any jurisdiction that has got it right out of the gate. As you will know, the demands of creating a brand new legal market and brick and mortar retail stores, as well as the entire framework. I always say that for tobacco, we are still changing the regulatory structure a century in. And so I don't know any jurisdiction that's looked back and say, well, we nailed that. So revision change is a part of the process, number one. And I think what you're doing, as I understand it, which is to take lessons from what's happened, is fundamentally important. And getting over the fact that there are mistakes made and instead learning how to make the process more efficient. I also don't know anyone who said whatever the rules might be, they were as efficient as anyone would like, either from the public health or the industry standpoint. I can tell you in Canada, in that 5-year review, an important emphasis has been saying, okay, for the rules that seem to be working well, how do we make them more efficient? And you will know from issuing licenses to product testing, a lot can be done. And so I think that that is one that it's not a conflict between public health and the industry. Greater efficiency is in everybody's interest, and that should be a priority. But I can tell you that, you could get 20 different speakers and they'll give you a different perception of the balance. I would say that sometimes the industry arguments in Canada are being positioned to represent consumer interests, but that's not always the case. That's why I mentioned some of those rules about testing, some of those rules about product standards. A very simple one is that we have rules on how much THC can be in each edible. The industry doesn't like those rules, but I can tell you that consumers do, because they don't have to nibble the leg off a gummy bear to try and get the right amount. They can actually just have more pieces because they know how much is in each piece. So, I think there's more than one interest here, but, and I don't think you're going to find some Shangri-La where everyone agrees they're in balance, but I think you can have your cake and eat it too. And I would argue that it's in the industry's long-term interest to have a well-regulated market that works for consumers, that avoids some of the concerns about greater use and problems with kids. I would say that those are in the long-term interests of the cannabis industry in Massachusetts and in other states as well.
Excellent, thank you. Questions from the committee? Yep, Representative.
I'm very curious how having something legal at the country level, the federal level, simplifies your work.
I mean, hugely. Whatever the challenges in Massachusetts might be, the federal landscape in the U.S. is far from ideal. And so many of the challenges with, call them whatever you want, but CBD, Delta-8, HHC, those are specific to the regulatory patchwork. And they're causing problems for essentially every state, regardless of where they land. So, I mean, it's huge. I will say that issues around the illicit market are very different here because you don't have the same diversion across state lines. It's not a big deal for folks. People aren't moving cannabis products across different provinces illegally because there's not really an incentive to do so. And so the situation, I'm sure, changes as your neighbors, the smaller geographic areas also have, similar laws. But I mean, I can't underestimate how important it is to have some kind of harmony across geographic areas that are in close proximity. It just removes a lot of the challenges.
So hemp-derived THC products did not enter Canada?
They're around, but so first of all, I will say that Canada's federal framework, we don't make the distinction that is made down in the US. So a non-THC hemp-derived product is actually regulated the same way as THC products. It has to be sold in the same stores. It's subject to the same rules. And that has simplified things. But I can tell you that there's certainly a market for, I'll put it in quotation marks, but therapeutic CBD-only products. But the products that you have down there, which are essentially using that as a loophole for products that have psychoactive, like Delta-8, they exist, but nobody uses them because they don't play any role because you've got THC, Delta-9, your typical cannabis products are legal everywhere. So they don't need to exploit a loophole. So those are very much specific to jurisdictions like the US, a little bit in some European countries where traditional cannabis remains illegal.
If you don't mind, could I ask one more question about medical use?
Yep.
One of the oddities in Massachusetts is that I think a lot of people are taking these edibles for anxiety, pain relief, insomnia. But there's a weird in-between. It's hard to get medical advice. So how do your provinces handle the treatment of these products as real drugs to address verifiable medical conditions?
Well, interestingly, we've had legal medical cannabis for over 20 years now. There is a process to become authorized as a medical cannabis user, but you don't source your products any differently. you would go to the same store that someone else might go to for a so-called non-medical or recreational. So, and I can tell you that people seeking authorizations have dropped in half since we've legalized adult use recreational cannabis, because it sort of begs the question, well, what do you need it for if you have access to the same products? So one of the big questions is, do we maintain this sort of medical authorization when we've got a legal market? It would be like having medical authorization to use alcohol or something when you would go to the same store. So that's the broad question. On the specific one that you ask about, so people aren't prescribed cannabis for a particular condition. And it's not like we have authorized cannabis products, well, they'll write you a prescription. You still go and source the same product as anybody else. There are all sorts of misperceptions. I remember our big national task force said that cannabis is one of those substances where we have lots of folks that overestimate the risks and underestimate them, and that's true of the therapeutic benefits too. So what it is it's a challenge of having a medical scheme without the approved products, which is typically how it works. The doctor will typically say, oh, you have this, I'll write your prescription. But we don't have approved cannabis products for certain conditions. So I don't have a satisfactory answer for you. If it feels very muddy and a bit of a mess, I would say it's the same situation up here. But actually the medical stream is kind of starting to dry up because it doesn't provide consumers with much advantage in a totally legal market.
Thank you so much.
Other questions from committee? I'd just like to explore one thing that you had brought up or had discussed was the division of the regulatory. So in some provinces you have, so you have a licensing enforcement and then it's separate from kind of the. So in a previous kind of speaker had also talked about trying to maybe, the difficulties of having an agencies working across agency lines. Are there lessons for us to be learned from kind of having a division? Is there a way, we've basically put licensing, accountability, enforcement all under one roof here in Massachusetts and in many other states. And on top of that, have added on social equity constraints and other programming that we need. And has there been is there a lesson from you where we could, is it too much to put on one agency? Has it become inefficient having it in over agencies, or just any of those experiences?
Yeah. I mean, I think the division I described in Canada is a little bit unique because they are literally selling cannabis. And there's more of a reason to have a bit of a firewall between the folks that are selling and indeed competing with your private licensed companies and retailers and those that are making the rules. So that's probably a distinction that may not be relevant in Massachusetts. I think you're going to be better placed to talk about which is most efficient. I think it's inevitable that having some overlapping mandates in the same structure is going to be helpful. I mean, you don't want people talking about equity not being involved in licenses or whatever else might be the consideration. But I can tell you that the oversight of those agencies, some provinces have much more of an external input and have more like public health representation on the board of directors, for example, and some are more just sort of your typical government corporate structure. So it's more like the composition of those in the oversight responsibility that is making the difference, not the structure itself.
Excellent. Thank you. No questions from the committee, so we're good. Awesome. Well, I would like to thank you very much for your testimony. Appreciate the background, and we'll certainly look into some of those papers that you suggested. So thank you very much.
Best of luck with your work.
Thank you. All right, moving on to next presenter. We have Mackenzie Slade from the Cannabis Policy Consulting. So Mackenzie, are you with us? There we are.
Yes, can you guys hear me all right?
We can hear you, absolutely. So thank you very much for joining us, and please provide your testimony. Thank you.
Great, thanks. Hi, everyone. First, thank you for the opportunity to provide testimony today on the topic of the multi-member commission models for regulated cannabis. I deeply appreciate the opportunity to contribute to the discussion. My name is Mackenzie Slade. I'm the Executive Director of Cannabis Public Policy Consulting, and I'm an implementation scientist. Since I am last up here on the docket and because I have to go after two very esteemed professors here. I'm going to try to keep it short and not be redundant to the testimonies that have been already provided, which will be, I'm sure, a little bit difficult, though there will inevitably be some redundancies. But I am glad to go after Professor Hammond. As a public health professional, I typically take the lens of a public health professional when I go through these type of providing testimonies. In this case, because you've already had some such excellent testimonies on public health, I'm going to come from an implementation science perspective. And so the field of implementation science, if you're not familiar, we study bottlenecks, we design and test interventions, and then we evaluate the real world impacts of implementing these policies and programs. And it's particularly focused on the design of policy and the design of interventions and programs. And so I've been studying this in cannabis specifically for the better half of the decade after co-founding CPBC back in 2018. And so CPBC, Cannabis Public Policy Consulting, we've worked with over 25 government agencies on the matters of cannabis policy, cannabis research, and program implementation. And I've helped stand up several medical and adult use markets from points of active sort of architectures of the legislation to standing up and evaluating mature markets. So anywhere within that spectrum of start to finish. And so today, like I said, I'm going to try and offer my perspective based on my real world on the ground experience and some of my academic experience in implementation science, specific to governance structures for cannabis programs. So as many others have stated before me, there are two primary governance structures for cannabis programs. We have the executive director model, and then of course, the model that you all have, the multi-member commissioner model. And so the executive model, very top-down structure, pyramidic, falls into one single appointed individual who is responsible for the functions of the agency, both policy and administrative. And then the multi-commissioner model is more of a decentralized approach where authority is shared across multiple appointed members and of shared and equal authority, and then also have, in many instances, the executive director model underneath it. And so I want to start the testimony with the current structure of the multi-member model as observed today. But before I dive into some of the merits and the pitfalls regarding this model, I want to first reiterate what my colleagues have said, which is that there is no perfect model for cannabis regulation. I want to be very, very clear in that. And I appreciated Professor Landers, I believe, who had said that, you know, being reactive and changing is a common element and shows maybe progress in this space. So for better or for worse, there are only options based on the unique needs of your state and where your market is currently at. And so I've been fortunate enough to work with cannabis programs across the country, about which are 60% from my client base, about 60% of the states that I have worked with have the executive director models. And then I would say about 40% of are commission-like structures. And within each model, there are obviously pros and cons. And over time, these pros and cons change. And I'll go into each of those pros and cons to the best I can without being redundant. But I think it's vital to start the conversation with a baseline understanding that the ultimate deterrent of success for any model is dependent on the priorities of the state. And those priorities often change. So that said, governance models can change over time, and changes within them should not be viewed as a failure by anybody. Rather, it should probably be viewed as a moment of maturity. So on multi-member commissioner models for state cannabis regulations, and excuse me, I'm recovering from a terrible cold. As an implementation scientist specializing in cannabis regulation, my focus is evaluating the real-world outcomes of policy design, specifically as they relate to market efficiencies. And it is through this lens, focusing on outcomes instead of intent, that my work sort of leads me to begin with the pitfalls of commissioner models and where they fall short when it comes to cannabis regulation. So as stated by my colleagues, the decentralized decision-making approach in a commissioner models does hinder the agency's ability to make quick decisions and changes needed to adapt to the rapidly changing cannabis landscape. While a multi-member body, especially as designed as the one in Massachusetts, with the five topical experts as commissioners, it does bring a diversity of perspective. But the need for multiple layers of approval with a majority consensus can slow down the decision-making process, and often to the detriment of market growth or the safety of consumers. Because this is a nascent industry and to many still considered, I would imagine, a social experiment based on some of the last election results, adaptability and quick decision-making are essential for any regulatory body overseeing the cannabis industry. This is true of any nascent industry, but I think it's especially true of the cannabis industry. And as the market grows and new information and scientific research start to emerge, it does require regulators to stay responsive and adjust to policies as needed. I think Dr. Hammond speaking to the fact that we're still amending tobacco laws is a pretty prominent discussion point. And so there's this element of being reactive and being able to move quickly, but with the introduction of new products through legal and illicit channels, we really need to have a governance structure that allows for the adaptability for safety and compliance purposes. But I really want to build on the point of speed and adaptability from more of a market lens, as opposed to what you've probably already heard from government efficiency and public health. The number one piece of information that I have gathered in both my research and then on the ground with government agencies regulating cannabis is that for the industry to be maintained as originally intended, the regulatory body must make decisions in a manner that can outpace market outcomes. And so you've already heard the risks about regulating the nascent industry, especially one with a research deficit. In a nascent industry, the experts in the industry usually have the advantage of knowledge asymmetry. So cannabis growers and producers obviously are going to know far more about the supply chain than a regulator does, and that's to be expected. And in many cases, for proper governance, that is perfectly suitable and fine. But it is because of this knowledge asymmetry that industry outcomes often outpace our ability to regulate them. And this is a large problem for the long-term success of governance of cannabis markets, because cannabis policy is very sensitive to what is described as path dependence. And what I mean by that is that the set of decisions we are able to make in cannabis policy today is very limited by the decisions made in the past. And so this is true for not just the state of Massachusetts, this is true for every legal market, and it's true for markets outside of cannabis, but cannabis in its current form is especially sensitive to path dependence. So when legalizing cannabis, we create a new market and not just legalize an industry. And I think that's an important perspective that we sort of start with. We are creating a market, we are creating an economy. And from an economic perspective and an implementation science perspective, that market is going to make decisions within its ability. And so if current law doesn't actively prohibit something, the market will adapt. And that's not to demonize the industry and say that they're always seeking for different ways to try and one-up each other. It's actually just the opposite. I would say that it's a sign of market adaptation is a sign of competitiveness. There's only so long that industry players can compete on potency and price. There comes a time where they have to adapt and try something else. And that's a positive element when you start to see competition. However, the governance model selected must be prepared to adapt with the industry, not reactive, not after the industry. And so the best example I can provide is how many states originally defined THC, which allowed for the proliferation of cannabinoids in the regulated market, most notably Delta-8. And another example would be some of the product forms or ingredients based on a very limiting prohibited list. In both of these examples, which at the time were quite unforeseen by governments, the governance model among all states were forced to create policies or recall procedures in this posture of reactivity. And some states, of course, move quicker than others. So for some states, regulations were drafted and products were removed from shelves, and we were able to sort of accommodate the rapid pace of maturity. For other states, for many of which required statutory amendments, and that's an important element of speed, but for many of states that didn't require statutory amendments but had different governance structures, the inability to react swiftly meant that the allowing of alternative cannabinoids or products into the market, despite research on their on their health outcomes, the sort of availability of products became so pervasive in the time that it took to react, creating a prohibition and recalling them made less practical sense than simply authorizing the sale of these products. And this is a pretty prominent example of path dependence, which was the decision or the slow sort of reactivity time to allow for THC or other than Delta-9, or allowing the product forms that were currently on the shelves, has shaped the current market and the availability of products that we see today. And this example has pretty limited consequences. Like, obviously, there's public health concerns. Obviously, products that are not deemed safe should not be on market, should not be on shelves. But this example has limited consequences overall. This is like so other forms of cannabinoids might be available within the regulated space. We will now regulate those. But this is an example of why efficiency and governance matters from a market perspective, because this is one of many, many instances by which the industry will attempt to outpace our ability to regulate them, and as a result, have a different market than what was originally intended. And again, this isn't a jab at the industry, it's to be expected in some ways. And so as these events should be expected, what is particularly true among the backdrop of hopefully sometime in the near future, federal legalization, efficiency and governance is imperative to protecting against past dependence. And so what I am suggesting is that the speed of governance is not just important for the sake of getting the day-to-day work done, for issuing licenses, for getting products on shelves, for maintaining data protocols, whatever else you can think of. Speed in governance is imperative so that we don't allow for the unforeseen events to shape our future market and make the decisions we will be able to make in the future. And so the commissioner model is extremely well intended, bringing together diversity and thought leaders. It really is a very well-formed model. However, its decentralized approach can shape markets to stray from their original design. And I think that that's sort of what I really want to drive home from an implementation science perspective, is that speed in governance shapes markets, shapes market design, and market design shapes outcomes. And so if you look at the tobacco industry from when it originally started to where it is now, it's extremely different, of course. And in a lot of ways, that's to be expected. Your governance model should be able to be move as quickly as possible in a way to make sure that market design is maintained. And again, particularly true amongst federal legalization. And so before I move on to discussing the executive director model, there are obviously benefits of the commissioner model that I would like to sort of talk about here. And it should be taken into consideration as you evaluate what is best for the state and its regulated cannabis program. As previously noted, the multi-member model definitely brings diverse experiences, insights, and knowledge all brought to one table, can lead to well-rounded policies and truly try and prevent an echo chamber in the decision-making process. It can also, its original intent for public administration was to promote transparency. And there are reasons to think that it does that far better than that of an executive director model. There's actually an academic text that if you specialize in public administration, they sort of beat into you, called Concept and Cases in Public Administration. It talks ad nauseum about transparency in the governance models for multi-commissioner members. And so there's a built-in checks and balances system that helps prevent any single individual from wielding too much power. These things are all great. However, I bring it back to my original point that the efficiency isn't just about the ability and speed to be reactive. It's also about the ability to be proactive. And so the weaknesses of the multi-member commission model are conversely the strengths of the executive director model. A single appointed leader is far more conducive to swift decision-making. The model eliminates the need for multiple approvals or consensus gathering, allows the agency to respond better to unforeseen events, which is my real concern. That should be expected as markets mature. There's going to be a lot more of those instances than just products, making different types of products or different types of alternative cannabinoids making it to product shelves. And some will have a greater sort of consequence than what has been previously seen. And so one of the number one pieces I think that's maybe been lost in this conversation is it should be maybe less about the leadership model and more about the staffing. You know, the regulatory body sort of fits, I'm trying to think of the best way to say this. From my experience and from literature, the commission-based cannabis states tend to have lower morale amongst the employees doing the day-to-day work and potentially lower employee engagement. I think the answer for this is kind of obvious. The people that are doing the day-to-day work and answering to the people of the industry aren't necessarily seeing themselves as the thought leaders or contributors to the decisions being made. And that's just those layers of separation that can contribute to that. And conversely, from my experience under the executive director model, employees that we have worked with have certainly felt that their expertise and input are far more valued, and leading to engagement and stability and turnover. And so I think at a time where it's especially hard to recruit talent in government, this is extremely important. We can talk ad nauseum about the commission model and the executive director model as a leadership issue, but I see this personally as a consultant who's typically training mid-level staff. The people who carry out the orders of the authority are, if not more important than those making the decisions at top. And their ability to feel complete and as part of the process of decision making is very important. And I can tell you that there are certainly worse outcomes with turnover at middle level management than there are at top level management. One daily workflow operation interrupted without proper training or a transition plan can result in 10 times more lasting inefficiencies and delays than at the decision maker level. And obviously at the decision maker level, is where the sort of path dependence questions, like the decisions that are being made, shape those of the future. But the actual day-to-day operations are just as important to making sure that products don't end up on shelves that shouldn't be. And so employee satisfaction is also often strongly influenced by leadership style rather than structure itself. So of course you can get a poor executive director, which would obviously contribute to poor employee morale. So I'm not saying it's the only way, but I am saying that there's a vast difference in employees feeling like a cog in a wheel than feeling like a cog in an inefficient wheel. And so I don't have specific data on that for cannabis agencies. I would highly recommend doing some sort of research regarding employee satisfaction within the commission as well as within other states if possible. But there are, of course, drawbacks to the executive director model worth noting, notably the concentration of power to any single person. It really relies heavily on their vision, their competency, and their expertise. And it's for that exact reason that when I go around to states with my team, we sort of say that the best person to lead this effort isn't exactly those with the most topical expertise. It's those who have the most demonstrated ability to lead a team in your government. So where to go now? Obviously, each model has their merits and their pitfalls. And what the state must now decide is where to go from here while trying to remedy past issues under the commissioner model and while onboarding a new executive director. And this is really, really challenging, and any disruption in the status quo could lead to further issues. And I want to just make sure that that's stated because you are in a unique position than other agencies who might be looking to change up their model or might be looking to adapt. You do have a new person that you are onboarding as a position of leadership and do have a lot more at stake here. And so the challenges that are being experienced in Massachusetts are likely far more related to culture and politics than they are of governance structure. And that's also something that's important that I would recommend some additional research on. I don't want it to make it sound like that the commissioner model is the only way that things happen inefficiently. It's not. We've seen many states with executive director models have their own struggles. And so there could be other root causes of what's sort of driving some of the inefficiencies around rulemaking, as well as some of the inefficiencies around what the audit had found. And so because of that, I provide no formal recommendation on what the state should consider. But what I will say is that there are some suggestions that may be worth pursuing. And I think one of them that really sticks with me is that the benefits of the commission model obviously include this diversity in thought and perspective for the topical areas that are assigned to them with cannabis, and that's fantastic. But I think this well-intended effort overlooks the idea that government should be considered a stakeholder. Everybody who is every one of the agencies who has appointed a commissioner based on their topical expertise should still be continued to be engaged. Just because they have representation on the commission doesn't mean that the agency should not be conversing with them. And so I think the other element of this is that the engagement with a single topical expert does not replace the need for engagement with people within its department, and that there are going to be trade-offs in the industry, just like any other policy. This is economics 101. We have to get much more comfortable with the idea of trade-offs among these topical areas. And so I think that the current appointment structure may fail to recognize this. And ultimately, the number of commissioners may be best revisited by priorities of the state as opposed to the topical expertise. And that the engagement by the agency to stakeholders for each one of these relevant areas should continue to be quite robust, regardless of representation on the commission. And that can just be done through a memorandum of understanding between interagencies. And then finally, I think that the commission model in its current state may inadvertently incentivize the executive director to focus on relationships with the commission as opposed to focus on relationships with the stakeholders and the industry at large. I think that's pretty important. We've seen that across the states as well. again, I reiterate, regardless of the model, the agency should consider stakeholder engagement and prioritize relationships with stakeholders. And not to say that they've only been prioritizing that with the commission, but it certainly incentivizes a lot of effort to be placed within the relationships with their commission. And then finally, the benefits of the executive director model. But the rule promulgation being conducted by the commission, I mean, that I think can probably be revisited. This can be done by those who are having the day-to-day oversight of the operations within the ability of Massachusetts law. I think you spoke to this earlier. There might be some challenges in moving past the charter, but I would say that that's something that could be considered. Regardless of what model or structure or whatever changes that the state wishes to pursue, I would just remind everybody that policy should never be made without empirical data and the need for robust research across all models. There's a need for robust research across all models. And I know there's been some baseline studies. I would highly suggest doing annual reports on all of these things. That's certainly helped in creating a much more swift response and being proactive to certain things, such as the unforeseen expected events. And there's a saying in implementation science that I'll end with, because I know I'm just out of time, which is that do the simple thing that works. This is what we say to each other, do the simple thing that works. I think in cannabis policy across the country, we sort of added complexities in hopes that they would be protective measures. We came from a place of being maybe a little bit more in fear that representation was not going to be considered, or that all of these elements that are included in cannabis policy would be forgotten. And I think what we've come to learn is that the bureaucratic complexity is actually more harmful than helpful. And so I thank you for your time. Again, I apologize for the nasally cold, but I'm here to answer any questions you may have.
Representative Saunders?
Thank you, Mr. Chairman, and thank you, Ms. Slate, for your testimony. But two questions. The first has to do with the state of the industry in Massachusetts, age-wise, the maturity of the state, and in your experience, in other jurisdictions, does the commission model work better at the maturity that the Massachusetts market is in? And in addition, with the relative competitive market that Massachusetts finds itself in now, where when legalization was, or adult use was first introduced, we were effectively on an island here in Massachusetts, and now we are joined by a number of our New England and Northeast states in a similar legal status. Have you seen one way work better than another?
Yeah, I've been consulting with the state of Maine since 2019, so it's sort of in parallel to Massachusetts. I would say that's probably the leading in terms of latency. I will say that my experience suggests that the executive director model does work best. From the perspective of an implementation scientist, that has been my experience. I can't speak to some of the other elements that beyond that of implementation science and beyond that of efficiencies in markets, but I would say that it does result in better outcomes, dependent on what outcomes you would prioritize. So I just want to keep bringing this back to the point that every state has different priorities based on what their legislature has guided them to do. Some are very, very specific to public health, and some are very, very specific to having an industry and having a very, pro-business approach. And so I want to be sensitive to that in my statement that an executive director model seems to be possible.
Okay, thank you. And my second question, in Massachusetts, we have some very important, I think you referred to them as sort of topical expertise that we charge our commissioners to have. In jurisdictions where there is the executive director model, have you found successful ways for that topical expertise to be guaranteed in the regulatory structure there?
Yes, I mean, I think that some states do an excellent job at stakeholder engagement. I would consider Maine to be one of those. There should be full-time staff dedicated to stakeholder engagement and having a robust annual plan dedicated to how you will incorporate some of those voices. And I stand by that, whether you have a commission or not. You should be doing everything you can to do outreach to stakeholders of topical expertise, and also procuring for some of that expertise, right? Like having consultants on staff on the topics of social equity, I think is especially important because it's obviously a smaller group that is often marginalized and voices get drowned out easily. So I think that there are a lot of methods that you can take, but stakeholder engagement should be much more robust, and that's for any government agency, not just cannabis.
Thank you.
Could I just want to ask one question? I just want to thank you, too, for mentioning staff and their contentment with the work. So why does staff morale improve under the executive director model?
I think that the reason why morale is higher under an executive director model is that when the executive director is making the decisions and is the sort of conduit to the legislature, your day-to-day work and your ability to interact with them just generally is much more, heard, and you're asked upon, you're called upon to give your expertise and give your advice in your daily workflow. I think that's true for especially those who are managing workflows. For a lot of the agencies, how they're set up and how we recommend them to be set up is based on, your communications workflow, your stakeholder engagement workflow, and the people who are managing those workflows are often the people who the executive director will turn to and say, we have to report to the legislature on X, Y, and Z. In this case, I imagine for Massachusetts, the executive director would be saying, I'm reporting to the commissioner, who then will report to the other commissioners, who will then report to the legislature. Those sort of layers of interactions, kind of like, well, I'm not really talking to the person that's going to be making decisions based off of how I feel, and what I tell them is what I'm doing daily. So that would be my understanding.
Thank you so much.
Any other questions from the committee? All right, seeing none, thank you very much for your testimony. Appreciate your time. Thank you.
So much.
All right, I think that concludes those that are signed up to testify today. I want to thank the committee for your wonderful questions and for staying so engaged through this whole process. I think there was a lot to take in today, a lot to consider. So, close the hearing. Thank you.